share a little feedback with us. So again, our training today is brought to you by our partners over at Monterey County Works. And today we are joined by Laura Kirshner, who is the business services specialist there, who is here to share more about resources available to employers like you. Hi, Laura.
Hi, Anna. Thank you so much, and thank you to our partners at CEA for having us on today. We're delighted to co-host the labor law update, the 2026 labor law update. Some just information for some of our participating folks. You can learn more about us at MontereyCountyWorks.com, MontereyCountyWorks.com. That we brand the initiative. We are still the Monterey County Workforce Development Board, and we're just branding the initiative of the service itself. All kinds of different services for our local employers to take advantage of. We encourage you to review our website to learn about some of those. We've got job fairs and career fairs that you can sign up to. We do them on a weekly basis, so there's all kinds of opportunity for you to engage with us that way. We have customized recruitments. We've got on-the-job training to incentivize you to hire people who are enrolled in our programs and services, and that's a great opportunity. We can work with you to pay for half of their wages for the first 90 days they're on the job with you. So that's a great thing. There's incumbent worker training for those that have had people for at least 6 months on the job. You can take advantage of some of those services. Other resources are our hotline. The 1-800 number is a wonderful service for you. It's completely free. We encourage you to take a peek at that. We also have services for businesses that are going the other way called rapid response. So if you are in the midst of having to lay staff off and you just don't know how am I going to do this? What kind of, how can I be of service to them at a desperate time for them? We encourage you to reach out to us at the Monterey County Workforce Development Board, and we can help you blunt the blow of layoffs. Let's see what else we have. We've done employer hiring videos in the past, so if you want to take advantage of those, take a peek at our website, and we'll happy to make those available. We do have job fairs coming up this month. Again, there's one a week. We encourage you to look at our multiple employer job fairs if that's something that you're interested in and you're hiring anyway. Take advantage of our services. We usually have 10 employers here for our multiple employer job fair. There is room for about 15 thereabouts. We do them upstairs right here on premises in downtown Salinas. Pretty good place to host the job fairs. We had about 98 job seekers come in, so they're pretty well attended for small events. Thank you so much.
Awesome. Thank you, Laura, for everything that you and your team does for employers in your area. And now I'd love to introduce our trainer today. We have Juliana Gabriel, who is our Senior HR Compliance Director. So you are in great hands. And Juliana, it's all yours.
Thank you, Anna. Thank you, Laura, and the Monterey County Works for sponsoring this event today. Now I'd like to introduce California Employers Association, or CEA. We are an HR consulting company. We have members located throughout the state of California and beyond. And if you find you do need some additional support beyond that HR hotline that's provided to you for free by Monterey County Works, you can join us as a CEA member. All of our members get access to our hundreds of HR forms. So we have sample forms and policies and toolkits to help you stay compliant in your day-to-day HR practice. We are always updating those also with the new laws in California so that you can be confident that what you have is up to date and accurate. We can also help you out with HR projects. So if you need assistance with a customized employee handbook or some training or coaching for your staff, or maybe you'd like us to come and do an HR audit or I-9 audit for your business, we provide all of those types of services. So you can visit our website at employers.org. You can also call into us directly with any questions that you might have about that. This is just an idea of some of the different members and industries that we serve and workforce development boards. So you can see we have members of all different sizes and backgrounds, which keeps things fun and interesting over here at CEA. And I also want to note that this presentation today is for educational purposes only and should not be relied upon as legal advice. So just a reminder, CEA is not a law firm, so we are not giving you legal advice on these trainings or when you're calling in on that HR hotline. We're giving you education and resources and tools. So make sure if you have an issue of legal significance, you contact your own attorney about that. But you're more than welcome to ask questions about the content today. We want it to be very useful and practical for you. So please go ahead and put any questions that you might have in the chat box, and I'll be monitoring that throughout the training and maybe even answering some of those questions live. Otherwise, you do have that HR hotline that you can call Monday through Friday from 8 to 5. We are available for you. All right, so let's talk about what is on our agenda for the next hour or so. So we're going to kick it off with wage and hour updates. We do have increasing wages that went up on January 1st, and it's so important in California that we are paying people properly. There's a lot of penalties that follow if we're not classifying people correctly or not paying them correctly, so we want to get this right. We're also going to discuss some leaves and benefits updates, and this is going to be really important for your employee handbook. So you might want to take a look at some of your leave of absence policies, and we'll give you some guidance on what you may want to do in updating your handbook for 2026. We're going to spend some time today on some new employee rights. So we have some new immigration related rights, as well as some notices that have to go out that are brand new for 2026. And we're going to talk about what the deadlines are for those. So we're going to want to take good notes on that as well. We're going to cover artificial intelligence. That was kind of the phrase of last year. We just heard it everywhere. And California is one of the first states to start to regulate that in the employment space. So we'll talk about, as an employer, what do you need to know in terms of AI? And then sprinkled throughout, we'll have case law and regulations that we'll go over. All right, so starting off with wage and hour and payroll, as I mentioned, we're going to talk about those increasing wages that went up on January 1st. We're also going to talk about some changes that were made to California's Equal Pay Act. And if you're not sure what the Equal Pay Act is, that's okay. I'll give you a refresher on it, and then we'll talk about what changed for 2026. And then I'm also going to touch on OBA. This is known as the One Big Beautiful Bill Act, or HR1. This was a federal law that passed last year. You might have heard phrases like no tax on tips and overtime. So we're going to cover at a high level for employers, what do you need to know about that? All right, so starting off with our 2026 minimum wage, it did go up by 40 cents. So as of January 1, California's minimum wage is now at $16.90 an hour. And if you're wondering, it seems like these minimum wages have just been bumping up year after year. There's actually a reason for that. So back in 2016, there was a law passed known as SB3 that basically says every time the consumer price index or inflation exceeds a certain amount, it's going to result in these automatic triggers of increases to the minimum wage. So that's what's been happening. That's why it went up to $16.90. Now, what some people don't know is that the minimum wage also is going to impact the exempt employee salary. So for your exempt employees, that salary needs to be 2 times the state's minimum wage. And then you multiply that by 2080 hours a year to get the annual salary. So every time the minimum wage goes up, that's going to bump up the exempt salary amount. So for January 1, that got increased to $70,304. And remember, to be properly classified as exempt, meaning that you don't have to worry about tracking their time or overtime or meal and rest breaks, they have to meet a duties test. So they have to be engaged in certain duties known as the professional, executive, and administrative exemptions. And they also have to meet that salary minimum. And you cannot prorate that. So let's say you have an exempt employee and maybe they're only working 20 hours a week for you. So you want to know, well, can we cut that amount in half? And the answer is no. To be classified as exempt, that is the minimum that they need to make. And so if you're not able to sustain that in your budget, you're going to want to reclassify them to a non-exempt hourly employee. Anybody in California can be non-exempt, but to be exempt, we have to overcome those hurdles. And then California's minimum wage has actually gotten more complex in the past few years because we now have industry-specific minimum wages on a state level. So the first big one was for fast food chains. So for employees working at a fast food chain with over 60 locations nationally, they are at a $20 an hour minimum wage. And that does also apply to franchise businesses. There was some talk about that getting bumped up to maybe possibly $20.70 an hour, but we have not seen the Fast Food Council take action on that, but just be aware that's kind of floating around. It's been proposed by employee advocacy groups. And then healthcare also has their own minimum wages. Those depend on the facility type. So they currently range anywhere from $18.63 to $23 an hour. And there are set increases for certain facilities going up on June 1 of this year. So you're going to be wanting to look out for those mid-year increases if you are in healthcare. Our California DIR has some really helpful FAQs, so I would encourage you to go look at those, and they define the different facility types and minimum wage schedules. All right, and then to just add kind of more complexity to the mix, we also have local minimum wages in California. We now have over 40 of them. Depending on where your employees are working, you may need to pay them more than that $16.90 an hour. We have some minimum wages that are up to 19 plus an hour. And the key here is that local minimum wages are based on where the employee is physically performing the work. So you want to be thinking about your remote and hybrid workers. If they're in a different city or county, you want to check, well, what is the local minimum wage in that area? Same thing if you're sending them to a client site out of town, or maybe an out of town conference in San Francisco or LA, then the local minimum wage would apply there while the employee is physically performing work there. So make sure you're keeping up on those. A lot of the local minimum wages increased on January 1, and then there's also a handful that go up, or a little more than a handful that go up on July 1 every year. So we kind of have the beginning of the year and then mid-year increases that we have to watch out for. If you're a CEA member, we do have a link here for you to our minimum wage fact sheet that has all of the current local minimum wages. But if you're not a CEA member, again, you can call in on the hotline and ask any questions about where your employees are working, and we'd be happy to help you with that. All right, so now I'm going to focus on California's Equal Pay Act and SB 642. This was a bill that passed this year for 2026. And as promised, I'm going to start with just a little history lesson of what is this Equal Pay Act. So this is actually not a new law at all. It was originally passed back in 1949. It applies to all California employers. And the goal of it back when it was first passed was to address the gender wage gap. So statistically, women earning less for the same roles that men are performing. And so that was really the intent behind it. Now, over the years, over the decades, they've expanded upon it, added more protections to it. So where we stand with that today is it prohibits an employer from paying an employee less than what you pay an employee of another sex, race, or ethnicity for substantially similar work. So those are the three protected categories under this law. This is not to be confused with California's Fair Employment and Housing Act, which has many more protected categories, and that relates to harassment discrimination. So this relates to fair pay practices. So if you have employees that are in the same job classification or they're performing substantially similar duties, we want to make sure that they are being paid fairly, equally. Now, there are some exceptions where you can justify a pay difference or a pay disparity, where it's okay to have a difference in pay, even if employees are in the same job role. Those exceptions are seniority. So let's say that you have someone that's a cashier for you, and you have someone that just started 6 months ago, and then you also have a cashier that's been with you for 10 years. They might have a difference in pay because that person that has a lot of seniority with you has probably had increases over time, right? And so that's okay for them to have a pay difference for that reason. Merit would be another one. Maybe you just have one employee that just performs way better than another employee, and so you've given them increases. Now, I will say if you're relying on merit, make sure that you have good documentation on that. You know, save all those performance reviews, everything that went into that decision about what you're paying them, because if you get an Equal Pay Act claim filed against you, you're going to want to be able to defend yourself on that, on why. Production, you might have an employee that just brings in more income for the business. Maybe they're earning a lot more in commissions, right? Or another bona fide factor, which has been interpreted to mean something like training or education experience that's relevant to the job. You know, if you have a subject matter expert in an area, that might justify paying them a little bit more. All right, so that's kind of the landscape with California's Equal Pay Act. Now let's talk about what changed for 2026. So first, they amended the language. It used to protect employees of the opposite sex. Now they use the term of another sex. So it protects transgender and non-binary workers. You know, even if they're of the same biological sex as someone else, if there's a pay disparity there that's not justified, you know, they can bring an Equal Pay Act claim. They also expanded the definition of wages. So when they are determining whether you're paying people fairly, a court would look at everything, not just the salary or their hourly wage. They're going to look at benefits. They're going to look at vacation accrual rates, reimbursement. So basically, they're going to take a very holistic approach, and they want to know, are you being fair across the board on all of those things? They've also extended the statute of limitations. So it used to be that it was 2 years in most cases. Sometimes it could be 3 years, but they've extended it to 3 years in all cases, just meaning that employees have a longer amount of time to bring these claims. If a pay disparity or pay difference that wasn't justified happened within the last 3 years, they can sue for that. And then they've also kind of created this additional tricky rule where that employee can recover up to 6 years of damages. So they could go after back pay for that pay disparity that wasn't justified. So as long as a pay disparity happened within the last 3 years, they can bring their case, but then they could reach back all the way 6 years going after all of those damages. So it increases the risk, and liability exposure potentially for employers. So in addition to auditing your equal pay practices or fair pay practices, we would also recommend in terms of documentation that you're holding on to payroll records and anything that went into your decision of what you're paying someone for at least 6 years, just in case you need to defend yourself. The law requires that you're holding on to this for 4 years, but we would probably recommend expanding that to 6 years so that you can defend, why you've chosen to pay someone a certain way. All right, the other thing that SB 642 did is clarify California's pay transparency requirements. So California, along with a lot of other states over the years, have expanded on pay transparency, meaning the information that applicants and employees get to know about your wage rates, right? What could I potentially earn in this job? So again, to kind of recap on California law, what we've been required to do, anytime a current employee comes to you and they say, I want to know the pay scale, the wage range for my position, or if an applicant asks you for that information for a position they applied for, you have to provide it upon request. And that applies to all employers, regardless of size. Even if you're very, very small, you have to provide it if you get a request for the pay scale. They don't get to know everybody's pay scale in the whole company, but for their own current position or the one they applied for, they get to have that information. And then a few years ago, California expanded on that. And they said, if you have 15 or more employees, you actually have to post the pay scale right there in the job posting. And California is not the only state that requires this. And you might notice now, if you're on LinkedIn or Indeed, that we see those pay ranges right there in the job posting. And that's the reason why. Now, what they did for 2026 is they've amended the definition of the pay scale. And this is an important change, especially if you have 15 or more employees. So this pay scale now means the estimate of the expected wage range that an employer reasonably and in good faith expects to pay for the position upon hire. So they've actually limited it to the starting salary range now. It used to be, or it wasn't clear at least, most employers assumed that we had to provide the entire pay scale, right? So even if you had that 10-year employee or 25-year employee, their salary would have to be included in that wage range, right, that we would have to post. So this is actually, I think, good news for both applicants and employers. A lot of employers, said, hey, this is leading to a lot of mismatched expectations. People are applying and they think they're going to come in earning the top of the range and the salary range is actually, much lower. And so this is actually, I think, some good news for everyone. So make sure that you're, especially if you have 15 or more employees, you're taking a look at your job postings. Any ones you currently have out there, you're going to want to update it to just the starting salary range. And if you're working with any recruiters, make sure you also provide them that corrected information now. All right, so we're going to shift gears a little bit here and talk about personal vehicle usage, no pun intended there. So when employees are using their personal vehicles for work purposes, and we'll talk about what that looks like, we recommend that you use the IRS standard mileage rate, and that mileage rate went up for 2026. So let me kind of lay this out for you here. Our labor code, section 2802, requires employers to pay all reasonable and necessary business expenses incurred by employees. And one of those expenses can be when someone is using their personal vehicle beyond just commuting to work, right? Maybe we're sending them to an out-of-town conference, or maybe we've asked someone to go pick up lunch and bring it back for the office, right? Anything work-related that we're asking them to do while they're using their own personal vehicle. There's costs that are incurred with that, right? There is gasoline, wear and tear on the vehicle, the cost of maintaining insurance. We need to make sure we're reimbursing for all of that. And California has taken the position, if you're using this standard IRS mileage rate, then that is covering all of those costs. So you're going to be sufficiently reimbursing your employees. And so that IRS mileage rate went up. It used to be 70 cents per business mile last year. That went up to 72.5 cents per business mile traveled. So make sure whoever handles this function in your company, HR, payroll, make sure they are aware of that increase. If you only reimbursed for the cost of gas, for example, that's likely going to be considered insufficient. It's not taking into account those other costs of using the vehicle. Or if you use some other method, the burden would be on you to prove that it was reasonable if you get a claim. So that's why we really recommend using that IRS mileage rate. Now, also keep in mind that is only for reimbursement, and that applies to both exempt and non-exempt employees. For our non-exempt employees, our hourly workers, we also have to pay them for their time. So that's not compensating them for their time. That's for the, the cost of the vehicle. That is on the clock time if they're traveling beyond their normal commute for us for work purposes. So make sure you're also separately compensating your non-exempt employees for that, in addition to that mileage reimbursement. All right, so now I'm going to cover the federal law, OBA, known as HR 1. So again, this is the federal law that passed last year on July 4th. Now, OBA is a huge law. It has many tax-related and other changes related to the federal government's budget. So we are covering just a very small portion of that at a pretty high level today. This is not a tax webinar. But we're going to focus on some of the new federal income tax deductions. As I mentioned, you might have heard those phrases, no tax on tips or no tax on overtime. So what exactly does that mean? And what are you required to do as the employer? So OBA establishes above the line deductions, meaning it will reduce someone's taxable gross income for federal income tax purposes for certain qualified overtime and qualified tip earnings that apply through 2025 through 2028 taxable years. So it does also apply to earnings that happened last year. And I'm going to unpack each of these for you separately, starting with overtime. So you may recall that under federal law, under the FLSA, we have weekly overtime, that if someone works more than 40 hours in a work week, they're paid time and a half, right? They get that premium. So that overtime pay now, employees may deduct the pay that exceeds their regular rate of pay. So that is the half portion of time and a half. That's the premium that they're getting for those overtime hours. And it's up to $12,500 for individuals, $25,000 for joint filers. So quite a bit that now would not be subject to federal income tax. And for higher income earners, there are certain caps on it that phase in. Now, there's two really important points for employers and California employers specifically. So the first thing that you need to know is your obligation is to report the overtime, the qualified overtime that person earned. And then when it comes tax time, they take that information to their accountant and they're able to take advantage of that deduction. So for the employer, your main obligation is to report the information to them. But what makes it tricky, this is the second point, what makes it trickier for California employers is that only weekly overtime, the federal overtime, qualifies. So in California, we also have daily overtime when someone's working more than 8 hours in a workday. We also have this 7th consecutive day rule. When someone works 7 days in a row in a work week, that 7th day is all paid at overtime. So those California specific overtime rules are not going to qualify someone for this federal income tax deduction. It's only the weekly overtime. And so that could get tricky for reporting purposes, right? Because you're going to have to find a way to basically filter out the weekly overtime. So we recommend, if you haven't done so already, maybe give your payroll provider a call to see if they're able to tag or code weekly overtime in your system so you're able to generate that report. Now for 2025, that was known as a transition relief year. So you might not be penalized if you weren't able to do that or weren't able to do it exactly accurately. But for 2026, you absolutely need to report it. And they're going to be, it looks like, updating the W-2 with a specific box where you would include the qualified overtime compensation information for the employee. So put that on your list. Make sure that you are able to pull a report of the weekly overtime only. Qualified tips are pretty similar. So employees may deduct qualified tips from their federal income taxes up to $25,000. The only kind of slight difference here is that it's only for occupations that are specifically listed by the IRS. So they didn't want a bunch of people to start trying to claim federal income tax deductions and call things tips that weren't really tips. They have a proposed list of 70 different occupations, and it's the occupations that you would kind of assume would receive tips. So they have food service, delivery service, hospitality, entertainment, personal care. So it's actually a lot of folks that would qualify. But we do have a link for you here to the IRS guidance if you just want to see that and see if it applies to your employees. So again, we have the responsibility, just like with overtime, to report the qualified tipped earnings that we are aware of. All right, so wrapping up our wage and hour to-dos, we're going to first just make sure that those minimum wage rates have been, adjusted as needed. Also, just a reminder for our non-exempt, our hourly employees, we were going to want to update what's known as the wage theft notice. So this is a form that's required under Labor Code Section 2810.5. You give it at the time of hire. Our labor commissioner is a sample form that you can use for this. And it gives the employee information like rate of pay, overtime rate, paid sick leave. And anytime there's a change in that, you're going to want to give them a new copy of the form and save a copy for their personnel file. So anytime their wages get increased, it's a good idea to update that wage theft notice for their file. We also want to adjust those salaries for exempt employees as needed. Take a look at your pay practices. Make sure that you are paying people fairly, that you're addressing any discrepancies, and then update those pay scales in your job postings. If you have 15 or more employees, make sure it's just including that starting salary now. And if you do need additional assistance with wage and hour compliance, we do have a really great wage and hour audit, self-audit toolkit that can help you with that. And so we have a link there to our store on our CEA's website. All right. So we're about halfway through here, and I want to remind you, if you do have any questions, I know it's a lot of information, please go ahead and put that in the chat box. I would be happy to help you out and answer some of those questions live. All right, so now we're going to talk about leaves of absences and benefit changes in California. So we have had some updates for 2026 to crime victims and paid sick leave. And again, as I mentioned, those are going to likely impact your employee handbook policy. So it's an important area to pay attention. And then we also have some new restrictions on retention and hiring bonuses, which is a pretty big change. And we'll talk about what those look like. All right, so starting with crime victims leave, I want to give, again, just kind of an overview of what this is and how it's been expanded and changed for this year. So crime victims leave in California, what it provided or has provided is that if an employee needs to take time off because they were a victim of domestic violence, sexual assault, or stalking, they're able to seek court relief for the safety of themselves or their child and take protected time off from work to do that. So this applies to all employers. And so an example would be, let's say someone is experiencing domestic violence and they need to go seek a temporary restraining order. They could take crime victims leave to do that. Well, last year with AB 2499, they expanded upon that and they said, well, we're going to actually make it a broader definition of who's a crime victim. It's really anyone that faces any sort of physical assault or threat of violence. So it's not limited to just sexual assault, domestic violence, or stalking. So there's a lot more people that could potentially take this time off from work. They also amended the government code and they transferred enforcement authority to the Civil Rights Department. So our CRD, which oversees like harassment, discrimination issues, also now could potentially, audit and enforce these issues against employers for crime victims leave. Another big thing that they did last year is they created a brand new notice requirement. So even if you've never had a crime victim, this should be on your radar that the employer now must provide this crime victims notice titled for short Survivors' Right to Time Off that the CRD has published. And you might recall you had to provide it last year by July 1. But this is an ongoing requirement. So it's not something we just post up in our workplace. We actually have to distribute it to our employees. So to all new employees upon hire. So you're going to want to check your onboarding process, make sure that this form is in there. Also to all employees annually, we're going to want to distribute this every single year. And our CRD just updated the form in December. So if you did it last year, it's now been updated. It's a really good idea to make sure you have that on your calendar to do it again. And then anytime someone requests the form or they inform you that they or their family member is a crime victim, we need to provide this notice. The other thing that they did last year is they expanded the reasons for crime victims leave. If you have 25 or more employees, not only can your employee take time off to seek court relief, they can also take time off related to that crime for many other reasons. So if they need medical attention, victim services, mental health services, safety planning. Sometimes people are in a dangerous situation and they need to relocate, right? They need to get a new residence, and that might also mean they need to enroll their child in a new school. Or maybe they need to provide care to a family member who was a crime victim and is now recovering, or providing childcare or care to a dependent adult. So they can take time off for all of those reasons. And as you can see, this is a pretty long list. It's, pretty nuanced. It's a really good idea, especially if you have 25 or more employees. I would make sure that you have a crime victims leave policy in your handbook that's really clear on all of this. If someone needs to take time off for one of these reasons, it would run concurrently with family and medical leave. So California Family Rights Act, or FMLA, it would run at the same time as those leaves, and generally be limited to up to 12 weeks. And in some cases, if it's the family member that was the crime victim, a lot of the time it would be limited to 10 days. So again, a strong handbook policy is really going to help you out here in just understanding this leave. And if you get a request, you'll know exactly what you need to do. All right, so let's talk about what they changed for this year. They made some additional tweaks under AB 406. We call this kind of court-related leave cleanup. Basically, it seems like they might have forgotten about a couple additional provisions that they wanted to include last year. And so again, for those additional crime victims leave provisions, they used to be under the labor code. They transferred it to the government code, and they said the civil rights department is now responsible. They are the enforcing body of these rights. So these additional leave types apply to all employers, the ones I'm about to cover. So again, really good idea to check to see if your handbook covers this. So for employees who are victims, or who have family members who are victims of certain specified crimes, in this case, serious felonies, there's a specific list, they can take time off to attend judicial proceedings. And you might say, well, how is that different from what we just discussed? So before, we talked about they can take time off to seek court relief, like get a restraining order. The way I like to describe this is they can take time off just to keep tabs on their case, just to go and attend the proceedings, see how things are developing if they or their family member was a crime victim. So any delinquency proceeding, post-arrest release decision, plea, sentencing, conviction, or any proceeding where the right of that person is at issue, they can take time off for this. All right, so I have a question for you, and I'd love if you'd go to the chat and give your best guess here, and then we can discuss it. So do you think that employees can use their accrued time, such as paid sick leave, to get paid during a covered crime victims leave? Let me know what you think, and then we'll discuss it. All right, I already see the responses coming in. Thank you. You're all guessing yes. And you are absolutely correct, right? When in doubt, usually the most employee protective answer is going to be right in California. So yes, for these crime victims leaves that we talked about, employees can use their vacation, PTO, and mandatory paid sick leave. So while you, the employer, don't have to pay for it, it's unpaid by default, they could turn it into a paid leave. That is their right to choose whether they want to use their accrued time. And sometimes that's not always intuitive, right? Because you think paid sick leave, is that really a paid sick leave reason? But paid sick leave actually covers a lot of reasons not related to just illness or injury. The other thing that this law did, actually in October, they amended the law to clarify that employees can use accrued time, including their mandatory paid sick leave, also for witness appearance leave and jury duty. So if an employee gets a subpoena or court order to go testify in court, even if they're not a crime victim, maybe they just have relevant information, they're now under a court order to go appear, they can take protected time off for that, and they can use their paid sick leave or vacation time for that. Same thing with jury duty. So an employee who gets called to jury duty now it's clear they can use their paid sick leave and vacation, PTO, for that. And so you might want to take a look at these policies and see if they're clear on that. And train your HR or management team on that. And then also with jury duty, a lot of employers do choose to pay for it, even though you don't have to for your non-exempt employees. They choose to maybe provide 3 days or 5 days of paid jury duty. But you might want to evaluate, do we still want to offer that, knowing that they could use their paid sick leave or their vacation time for that? So take a look at these policies. So the ones we went over today, paid sick leave, crime victims, jury duty, and witness leave are all good ones to review. And CEA can assist you, as I mentioned, with employee handbook services. So you can reach out to us if you would like us to help you out with that. All right, so the next law is AB 692, and we're going to talk about this new restriction on retention bonuses. And I think the easiest way to understand these are what I call stay or pay contracts, or kind of bonuses with strings attached. So I think the easiest way is just to start with an example. So let's say that you have hired an employee and you give them a $5,000 hiring bonus, but you say to them, or in the contract, it says, if you fail to remain employed with us for at least 1 year, then we get to take that back. We get to recoup that $5,000. Well, as of January 1, 2026, this is no longer allowed for the most part in your contract. So employers are generally prohibited from requiring an employee or applicant to pay the employer back. Or you might say, well, we provided you this, the cost of this training or this tuition assistance, and now you have to pay the training provider or another third party if the work relationship ends. You're not allowed to do that. And the reason is California views this as against public policy. They don't want people to have basically this debt hanging over their head where they can't leave their employment and go elsewhere. They want people to be able to freely move around in the market. And so that's why this is now generally prohibited. Now, there are some exceptions that do apply. So they have these kind of very nuanced exceptions where if you have all of these different provisions in your contract, that you might be able to, kind of get around this rule. I would highly, highly advise that you consult legal counsel about that. If you want to take advantage of that and you say, we still want to do a retention or hiring bonus kind of with strings attached of some kind, make sure you do consult legal counsel, because those contracts have a lot of requirements to just fall into one of the exceptions. The other thing is we might see this one come back with additional clarification or some changes to it. When Governor Newsom signed it, he said that he wanted some, cleanup language and additional clarification. So we might see this one come back next year and maybe they'll soften it a little bit. All right, so wrapping up on our leave and benefit to-dos, make sure you are updating your leave of absence policies as we talked about, and then put it on your calendar to distribute that crime victims notice annually and make sure that it's part of your onboarding paperwork. And then if you do have these retention pay and tuition assistance programs, make sure you're reviewing those and adjusting any contracts moving forward, starting in 2026. All right, so now we are going to focus on some new employee rights and protections. As I mentioned, we have some new immigration-related protections where California has responded with basically all of the increase in immigration-related enforcement. So they have some new requirements for employers to kind of provide some safeguards for employees. I'm also going to talk about the California's artificial intelligence regulations. They title it automated decision-making systems. It's kind of a larger term. We'll talk about what that means, but we'll go over how is California regulating AI when it's used in employment. And then we're going to also focus on some new personnel records, notice, and posting updates. And as I mentioned, some of these have deadlines, so we'll talk about what those look like. All right, so starting with SB 294, this is known as the Workplace Know Your Rights Act, and there's a couple components to it, and this is the law that was passed in response to a lot of the increase in immigration enforcement. And one component of this law is a new emergency contact form requirement. And for if your employee were to ever be arrested or detained while they're working. And kind of the thought, I think, behind this law is the legislature was hearing about people who are being arrested or detained, and then their family members might not even know where they went. Maybe their children aren't getting picked up from school. And so they want the employer, if you know about it, if it's happening during working time, that you contact an emergency contact. So here is your first deadline that I want to give you is you must provide an opportunity for employees to name an emergency contact in the event that they are arrested or detained while at work or while working. And the deadline to do this is by March 30th, 2026. And this applies even if they are arrested for a reason completely unrelated to immigration. So it's much more broad than that. And it's voluntary. Employees do not have to designate someone, but you need to provide them the opportunity. So what I would recommend here, you might already have an emergency contact form on file. My guess is it's probably not specific to arrest or detention. So I would recommend that you make a new emergency contact form, and you could say, do you want us to notify this emergency contact in the event that you are arrested or detained? And if they don't, I would have a clear opt-out documented, so you can show we gave our employees the opportunity, right? And maybe someone, just doesn't want us to do that. This is also a form that needs to be provided to all new hires going forward. So you're going to want to add this to your onboarding packet as well. And we do, again, if you're a CA member, we have a sample form that you can use for that. Anna put that in the chat box now. Then, really important, if your employee ends up getting arrested or detained, you must notify that designated contact if the employee has one, if they were detained on your work site. If it happened off-site, the way that the language reads is that if it occurred, during work hours or when they were performing their job duties, then you need to notify if you have actual knowledge of it, right? If you have actual knowledge that it happened, they understand that you might not in that case. The penalties are really serious if you don't do that. So it's $500 a day for every day that you're not notifying that emergency contact, and then it would max out at $10,000 per employee per violation. So even though this is probably not likely to come up super often, you're going to want to make sure that you are training your HR or management team on this, that you have someone responsible for looking up and notifying that emergency contact in the event of an employee arrest or detention. The other piece of this law is that there is a brand new notice requirement. So the Labor Commissioner has published a Workplace Know Your Rights Act notice, and this informs employees of things like constitutional rights, rights when they're interacting with law enforcement, workers' comp, anti-retaliation, and a few others. We have to distribute this notice to all employees by February 1, so just in a few days. So if you haven't done that, make sure you do that. You can distribute it personally or send it via email is fine, as long as your employees are likely to receive it. We also do have to provide it annually and to all new hires. So again, it's a document that we're going to want to have in our onboarding paperwork. So the two deadlines that I gave you, March 30th for the emergency contact, February 1 for this Workplace Know Your Rights notice. And it does need to be in the language understood by your employees. There is an English and Spanish version that the Labor Commissioner has published. And they said if they haven't published in your language, then you can provide the English notice. All right, so now turning to AI and automated decision-making systems, as I mentioned, let me define this and then we'll talk about how California is starting to regulate AI. Oh, and looks like we got a question that came in the Q&A. Is the Know Your Rights notice revised every year? It can be. So that's going to be up to the Labor Commissioner. If it's like other employee notices, then I would say yes, it's a definite possibility to be updated from year to year. So you're going to want to be checking on that before you send it out. Great question. All right, so an automated decision-making system is any computational process that makes or facilitates human decision-making through artificial intelligence, AI, like ChatGPT or Copilot, machine learning, statistics, or other data processing techniques when you're using that tool to make employment decisions, who you're going to hire, who you're choosing for a layoff, who you should promote. If you're using that AI tool or a similar tool to do that, that is what California is now regulating. So AI falls under this larger ADS umbrella. But when you hear ADS, AI, those terms are kind of interchangeable. So last year, the Civil Rights Department approved regulations, and what they are specifically aimed at, it's actually a very small issue. It's aimed at when that AI tool may lead to discrimination. So when potential discrimination may happen. And an example that I can give you, there's actually lawsuits starting even on a federal level with this. There's the Workday lawsuit where it's being alleged that an employer was using an AI tool to screen resumes, which we're hearing is happening a lot now, right? And that AI tool is allegedly screening out older workers over 40, which is a protected class. So it's leading to potentially age discrimination. And even if the employer is not aware that that's happening or they didn't intend that to happen, they can still be on the hook for that. They can be liable for discrimination. And that is what these regulations basically say. So they say our Fair Employment and Housing Act regarding harassment discrimination applies when an employer is using an AI tool. So you're using that AI at your own risk. And an AI tool may result in what's known as adverse impact discrimination. So that's when you didn't intend for it to discriminate, but it's unfairly, having a negative impact on a certain group, a certain race, a certain gender, religion, age, etc. Right? The other thing that this law does is create a new record retention requirement. So if you are using AI tools to make these employment type decisions or help you make those decisions, you have to hold on to that for 4 years from the date you created them, or the personnel action taken, when you decided to hire someone or who you selected for the layoff, whichever comes later. So you're going to want to make sure you're maintaining record of that. So that's where we stand today for the most part in the employment space for AI. I think we're just at the very beginning. I think even by next year, we're going to see a ton more AI related laws and regulations. California is one of the first ones, right, in the employment space, but I think we're going to see that just across the board as they start to wrap their heads around, this technology. And there was a law, you might have heard of, SB 7, that was going to further regulate employers' uses of AI and make a lot more notice and transparency requirements for employers, where you'd have to let people know you're using the AI. That did not pass. It was vetoed by Governor Newsom. But it's likely that we're going to probably see these types of, bills be introduced to the legislature in the future. So I wanted to ask you all a question because I find it interesting. How many of you have an AI policy in your handbook? Let me know in the chat. You can just put yes or no. It's interesting because I think a lot of employers right now probably are not addressing AI. That's what I've seen on these trainings, how most people answer. But I would recommend that you consider it. If it's at all possible that your employees might use AI in any way, especially if you're in an office environment. Now when you Google, the AI tool just comes up right there. And so you might want to decide for your business, well, what are the permitted uses for AI? Are we all for it? Like, use it as much as you can? Do we want some limitations on that? Do we want it used for employment purposes at all, right? So those are some of the things you might want to address. And it looks like a couple of you are saying, no, you don't have one, which most employers, I think, don't at this point. The other things you might want to address is, what you feed into that AI tool, what you put in there, is not necessarily confidential. So we don't want trade secrets being put into that AI tool, or confidential personnel information, medical record information, right? So it's a really good idea to start thinking about an AI policy and putting it in your handbook. CEA does have a sample policy for our members, and that is something that we can help you out with, especially if it's something that will be used in your business. All right, so the next law that I'm going to go over with you is SB 513, and this has to do with personnel records. And so again, I'm going to give you a little refresher here, and then we'll talk about what the new requirements are for 2026. But just as a reminder, anytime a current or former employee requests to see their personnel file, or maybe they have a representative reach out like an attorney and they say, I've been authorized to, ask for this, we have to provide the right to inspect and receive a copy of their personnel records. So that is a right that they have. And within those records, you need to include any employee performance information, like performance reviews, and any grievance, meaning any complaint that involved the employee. And that is due within 30 calendar days of them making their request. If you fail to provide that timely, there is a $750 fine, but even, I think, the bigger stakes are they can get their attorney's fees and costs if they sue you. So it could be a lot more than that $750 that you're on the hook for. There's a very similar rule with payroll records. Payroll records carry their own $750 fine, but for payroll records, they have to be turned over within 21 calendar days. So you have to do it a little faster. Usually when someone's making one of these requests, a lot of the times they're going to ask for both at the same time. All right, so let's talk about what's been updated for 2026. So now when you turn over personnel records, they also have to include education and training records related to the employee. So that means name of the employee, name of the training provider. So let's say you had CEA come and do harassment prevention training for you, right? You would name the third-party provider. The duration, meaning the length of the training. Was it an hour, 2 hours? What was the date of the training? Core competencies of the training. Basically, what was the content, right? What did the training cover? And including any skills and equipment or software, and then any resulting certification or qualification. Now, what's a little bit of, I think, a problem with this law is they don't define education and training records. So it could be really, really broad, right? It could be, any onboarding training that you do, any learning management system video that your employees watch, harassment prevention training, right? We would recommend erring on the side of caution and now keeping records of all of this content, because if you do get a personnel record request and it's not in there, right, you could potentially be on the hook for that fine and the attorney's fees. So it's not necessarily difficult, but administratively burdensome to track this. So you might want to think about who do you want to make responsible for tracking that information for your employees. All right, and the last law we made it that we're closing out on is labor law posters and notices. So you might be aware that we have to have state and federal postings up on our wall in our workplace in a location where employees are going to see them. And for some of the postings, if we don't, there's pretty significant fines if a government agency were to audit us. So if you have, a lot of employers will order one of those all-in-one posters where it has everything on there. If you have a 2025 version, make sure that you get one for 2026 because there were some postings that were updated. So the Cal OSHA Safety and Health Protection on the Job was updated in July. The California minimum wage order, this one gets updated every year, every time the minimum wage goes up. Also, if you are in an area that has one of those local minimum wage requirements, maybe outside of Monterey County, make sure that you are posting the local minimum wage poster. You can get that directly from the government agency website. The paid sick leave posting, the DLSE Healthy Workplaces, that one was updated. And then the EEOC Know Your Rights, that's a federal poster. It's been marked as undergoing revision to align with President Trump's executive order on gender identity. We haven't seen that one updated yet, but that one is on our radar that it might be updated. So make sure you have an up-to-date poster. We do have them available at employers.org if you need one. And then we already discussed these. So this is not more information, just recapping those notices that we have to provide every single year. So our crime victims notice from the Civil Rights Department and that brand new workplace notice of rights. So make sure that you are getting those out to your staff. All right, so someone asked, is there a deadline for posting the labor law posters? And then for the crime victims notice, I received a notification that it will be revised again this year. Do we have any idea? So it was just revised in December. They can unfortunately revise these notices at any time, but I think there's a level of reasonableness, right? As long as you're doing it within every 12 months, you've met that obligation on the crime victims notice. So I would just recommend every time you're distributing it to go directly to the CRD website, grab the most updated copy, and send it out. Do that every 12 months. For the labor law posters, those are supposed to be up on your wall year round. But what I've heard is you can show that you've made your good faith efforts in ordering the labor law poster. If you still have, let's say, the 2025 up on your wall, you've ordered the 2026 version. If a government agency comes in on January, 1 or in that month, show them that information so they see that you're trying to be compliant. What happens is for a lot of these all-in-one labor law posters, they have to wait on the government agencies to update them before that they can put them together and ship them out. So they're at the mercy of these government agencies to update those notices. All right, so wrapping up on employee rights, make sure to prepare that emergency contact form and give them the opportunity to designate that by March 30th. If you are using AI, make sure that you have human review of those processes if you're using it for employment purposes, that it's not discriminating or doesn't have some sort of bias, right? We still want that level of human review, and then make sure that you're meeting those record retention requirements of 4 years, and then ensure that you're complying with those new training and education record requirements. And also, I would recommend that you subscribe to our blog at employers.org. Anytime that we get updates when there is a revised notice or things of that nature, we do really timely post that on our blog. So that can be a way to kind of stay in the HR news. And then here's a little end of year checklist for you just to help, keep you up on those reminders. Make sure you have your updated labor law poster, keep that employee handbook updated. We recommend, reviewing that at least every year. Usually end of year is a good time when we have the new laws ready. And then make sure that you are keeping up on harassment prevention training. That is due every 2 years. So if you trained in 2024, you are going to be coming due in 2026. Mm-hmm. All right, again, I want to give a big thanks to Monterey County Works for sponsoring this event today. We really appreciate your partnership. And again, there is the HR hotline listed if you'd like to give us a call if you have any follow-up questions or any HR question. And here is our contact for Monterey County Works and Laura's email if you'd like to reach out to her, and phone number. And with that, I will turn it back over to you, Anna, to help close us out here.
Awesome. Thank you, Juliana, for leading us through that wealth of information in less than an hour and so clearly and comprehensively. We appreciate that. Yeah, just some more information about membership options here through CEA. As you saw, some of those are members only forms, just as benefits that our team has created for some of our CEA members. If you need a little assistance beyond that complimentary HR hotline provided by Monterey, we encourage you to consider membership with us. And then I just dropped a link into the chat. As I mentioned at the top of the hour, the way that we continue to improve these trainings and thus help you further is by hearing from you. So if you can either click on that link that I just dropped into the chat or scan that QR code that's on your screen, that will go straight to a very brief survey, 5 questions, takes about a minute. But we really do appreciate your feedback. And that's also how you suggest trainings that you'd like to see in the future. And then last but not least, we do have some continuing education credits for you if you are here for HRCI or SHRM. Your HRCI code 729913, SHRM code 26-HD2X6. CEAinfo@employers.org, or you can always call into that HR hotline if you need some guidance on redeeming those codes for recertification credit. And with that, I again want to say thank you, Juliana, for leading us and for always being so supportive for our employers. Laura and your team, thank you again for your generous sponsorship. And then another friendly reminder, 2 things. March 4th, that managing remote employees training. I believe that's also with Juliana. So we get a reprise. And then I will be, as soon as we wrap here and I can pull the report from Zoom, I will reach out to everyone with that PDF of the slide deck just to make sure everyone has access to that for your future reference. And look at that, 11 o'clock on the dot. And we look forward to working with you on all again. See you on March 4th for the next training. And then we will talk to you on that HR hotline. Thank you, everyone, for your time, and we'll see you soon. Cheers.
Thank you.